Good evening. This is Laws 12059 Conveyancing. This is week 3 in term 2, 2018. Now, I'm sure that those of you that are looking for your inspiration for the first assessment have been reading UCRU contributions, and Melissa Cook provided an excellent contribution, which was a QLS Proctor contribution guide. So if you haven't looked at that or found it independently, please do so. I hope now that you're starting to gather your thoughts in relation to the first assessment and you've got an idea of the layout, the structure. If there are any questions in relation to the first assessment or any assessment, please let us know tonight or during the week in UCRU. Okay, so in this unit, I want to identify some cases for you to consider. So here's case number 5. We've done 4 already, case number 5. So listen carefully and see if you can provide an answer. A young couple wish to purchase their first home. They approach a real estate agent who assists them in sourcing a property. They notice an extension at the rear of the house, and the agent assures them that everything is in order, but to be sure they should obtain a building inspection report. The buyers commission a building inspector who confirmed the home is structurally sound. They confirmed that they are satisfied in that regard. In the meantime, their solicitor had undertaken a rate search. But the problem with rate searches is that they'll often come in not long before settlement and after the date by which the buyer is to notify as to whether they're happy with building or pest. In this instance, the rate search came in a week after confirming the building report was in order and a week before settlement. And in the search, the council disclosed that the rear structure had not been approved by it. What's the contractual and legal situation? Do the buyers have recourse against the seller or the agent or the building inspector or their solicitor? What do you think? And any answers, generally speaking, default refer to the standard conditions of the REIQ contract. Okay, so they've come to see you. Question, would depend on what special conditions there were. Good question. Let's assume that the contract provided for standard building and pest within, say, 14 days, and the solicitors have advised the other side that they're satisfied with building and pest. Right, so what thoughts do we have? And you can take a guess.
Sorry, John, can I...
Yes, Leonie?
I was going to say seller disclosure before contract, based upon the fact that...
So do we say, so Leonie, do you feel that in those circumstances there's an obligation on a seller to disclose the fact that the extension was not approved by council?
Yes.
Okay, any other thoughts? Thank you for that. And Leonie also asked, is the contract unconditional? Yes, but I'll say something about unconditional contracts. Caveat emptor, says Rachel. So what do you think, Rachel? Do you think that there was no obligation on the sellers to disclose this fact and caveat emptor, let the buyer beware? They're stuck with it? Is that what you think? All right. Feel free to unmute your microphone if you wish. Any other thoughts? So what does the standard contract say? And this is a hint to say that what you should do is to have your contracts printed probably, or at least very highly accessible. And the main one would be the REIQ residential contract. The textbook works on one version. I've given you the version that was current at the time that we completed the notes, and it's a couple of weeks out of date now, but it's pretty close. All right. Have a look at clause 7.6. Those of you that are watching this session remotely after the event, you please do so as well. So has anyone dug out clause 7.6 in the standard contract? I hope that's the clause number. All right. So the standard contract provision provides that any notice issued by a competent authority, like a council or a court or tribunal, before the date of contract, which requires work to be done to the property, must be fully complied with by the seller. But what if in this instance there was no notice, there was no approval from the council, but is there a difference between having no approval and a notice from the council saying you have no approval, do something about it? Do you see the distinction that I'm trying to make there? So if the standard contract says that any notice issued by an authority like a council requiring work to be done before the contract is signed must be done by the seller, that's different to a situation where the council have never actually said anything about it until now. Until now, the buyer has done the search and the council have gone out, done an inspection or something and said, okay, well now that's illegal and we're going to issue a notice that has to be rectified. So here let's assume that there was no notice before the contract. The notice has now issued, and it issued as a result of the council coming out, finding the error, saying, that's no good, here is a notice, you must fix it. Whose responsibility is it to fix that extension that does not have the council authority? We're getting different votes. I like the answers with the question mark at the end. So we're getting, it's 2 for 2. We're getting 2 say the seller, 2 say the buyer. But interesting that the votes for the buyers are less confident there with a question mark. Any other votes? All right. The building inspector, the sellers, so the sellers are in front now. Section 47 of the QBCCA, says Leone. All right, for what it's worth, for my 2 cents worth, I think that we can assume that you would contact the building inspector. The building inspector says, look, I didn't check for whether it had been approved. My brief was to check whether it was structurally sound and built in accordance with code. And it was. It's structurally sound. There's nothing wrong with it. My vote is that the buyer stuck with it. And the reason for that is that the standard contract provides that any notice issued by a competent authority before the date of contract, which is different to the date of settlement, requires the work to be done by the seller. Therefore, by inference, any notice which is issued after the date of contract becomes the responsibility of the buyer. So in that instance, I think it's fair to say that the buyers have a very real risk of having to purchase the property and then pay for the cost associated with approval of the unauthorised work. As a solicitor representing people that come to you for advice before they sign the contract in relation to the acquisition of residential real estate, assuming for a moment that what I'm saying is correct, what do you think you would need to tell them in terms of this issue of building inspections, building approvals, council requisitions, and the responsibility? Any thoughts? Rachel says, put a special condition in the contract, which I think is probably a good technique generally, but then do your searches with council, maybe as soon as you can, before the contract if possible, but then you'd end up spending a lot of money on properties. Kayla says we have one for due diligence for the council. Yeah, so the point of this exercise and case number 5, I think, is to say that relying on the special condition the standard condition is fine. Sometimes you need a special condition, or at least if you're going to rely on the standard conditions, advise your clients accordingly of what it can do, but importantly, what it can't do to assist. Okay, well, thank you for your patience as we work through that, and I'll try and add some more case scenarios as we proceed through the unit. Tonight, we're dealing with issues of disclosure. We haven't quite finished the work that I wanted to finish from last week on real estate agent, but the two work in together. Seller's disclosures and the role and responsibility of the real estate agent are closely aligned because typically, in 99.5% of the time, who does the agent work for? Any thoughts? The seller. Yep. I think sometimes maybe some real estate agents forget that, think they're acting for both. I don't know. But they're actually paid for and commissioned and engaged by the seller. So when we're talking about seller's disclosures and we're talking about the role of an agent, you can see how the two are closely aligned. What's the principal piece of legislation you think that deals with issues to do with real estate agents and disclosure of issues to do with property? What's the act that comes to mind immediately? I'll give you a hint. It used to be... Yes, sorry?
Property Occupations Act.
Absolutely. And what was the predecessor to the Property Occupations Act, Bronwyn? Can you remember? You know the acronym, don't you? Everybody used to call it the acronym. PAMDA, which was the Property Agents and Motor Dealers Act. Okay, so the Property Occupations Act 2014. I'll give you a hint for the examination. If you haven't read that act, please do so. What I'm going to do tonight is make it even easier by going through what I think are the main sections. Now, there are other important sections in the legislation, so I'd like you to have a look at all of it, but you need to have a good working knowledge of the Property Occupations Act. So let's start with section 15. If you've got the act there, I'd recommend that for the purposes of this evening, you follow along. And one thing that you will notice if you're looking at this through Ostly is that Note Up is not helpful in terms of case law. So what I'd really like you to do is try and source some cases relevant to some of these more important sections if you can. Does anyone know where else you would look apart from Ostly to try to find cases? I'm testing your research skills now. Jade, yes, I love Jade. Jade, you're getting a few votes for that. And of course, just a reminder that if you're not already subscriber to Jade, you can receive information about areas of law of interest to you by email on a daily or weekly basis from Jade. So subscribe to Jade, have a look at Jade. It's a great resource. Okay, otherwise, on the University of on the CQU University site, we have the research facilities through LexisNexis and through Thomson Reuters. So they're the main other ones that we'd look at. Okay, Property Occupations Act, Section 15. Who is a property agent? Might seem a bit obvious, but there are actually three types of agents within the context of property. Quick quiz, what are they? In PAMDA, it used to have motor dealers as well, but we're not worrying about that. Types of agents when we're talking about property agents. Licensee, seller, principal, developer. Yep, they're all good thoughts. Not exactly the ones I had in mind. You've actually added a fourth one there I've thought of. Let's look at it this way. I think a real estate agent is probably the main one, but also an auctioneer. Yes, Caleb just beat me to that. And then you have agents that are licensed to let properties. And property developers are also, I think, useful to consider. But in terms of the actual definition, and Leonie said buyer's agent. Now that's really interesting because whilst almost always it's a seller's agent, buyers can actually commission an agent to work for them as well. So when we're talking about a property agent, for the most part, we're talking about a real estate agent, but also auctioneer. Now, I mentioned that there are three general ways in which a seller can commission a real estate agent. So what type of listings are available to a seller wishing to engage a real estate agent? Three words that I'm looking for here, very specific words. And they're all to do with listing. Open, exclusive, and sole. Exactly. All right. So remember the types of listings that are available. So an open listing, that's okay, Kayla. An open listing is defined in section 20. So what's the meaning of an open listing? It's a written agreement entered into between the seller and the property agent, who is the selling agent, under which the seller appoints the selling agent in accordance with the terms to sell the stated property under the agreement. So that's pretty straightforward, isn't it? It still doesn't tell us exactly why it's an open listing. What we infer from the meaning at the start is that it's an agreement to engage an agent to sell a property for you. That's fine. But here's the interesting part. Have a look at subparagraphs A, B, and C, because that tells you the nutshells about when the agent is entitled to receive money. A, the seller retains the right to sell the seller's property during the term of the agreement, or to appoint additional property agents and selling agents to sell the property. So that's interesting. Under an open listing, the seller can effectively compete with the agent, or can go further and appoint a different agent or another agent on a different open listing. So now you've got the seller competing for the sale, you've got the original agent competing for the sale, and you've got another agent also on an open listing competing for the sale. Section 20 goes on to say that the selling agent is entitled to remuneration, and this is a key phrase, if he or she is the effective cause of sale. So in an open listing, before the agent is lawfully entitled to receive any remuneration, must be the effective cause of the sale. And that's much more than just, I'm entitled to my commission because I fielded a call from the eventual buyer in 2 weeks ago, and I told them all about the property. Therefore, I'm entitled to my commission. As a seller, if you happen to sell the property yourself to that person, I think you would argue that there is no entitlement, no obligation to pay the commission, because the agent was not the effective cause of the sale. Also in section 20, it says that the appointment of a selling agent can be ended at any time by the seller or the agent. So it's very fluid arrangement, and unsurprisingly, in my experience, agents are not too keen on open listings. Now, because of the advantages available to a seller in having an agent on open listing, you can sell the property yourself and save the commission. Why would anybody want to do anything other than an open listing, do you think? Is there any advantage in having an agent on an exclusive agency or a sole agency? Less commission? Maybe. If it's a sole or exclusive agency, you might be able to reduce the commission. I think Rachel's got the answer I was looking for. If you exclusively or solely appoint an agent, then you might think that they will work harder to sell the property. They'll be more committed to it rather than looking to sell other properties. So what's then the difference between an exclusive agency and a sole agency? Have a look at section 23 of the Act. And it says it. This section, I think, is one of the most well-drafted sections I've read. I really like this. It's just plain English drafting, and it just says it. So, number one, the only difference, says the legislation, between an exclusive agency and a sole agency is the extent of the entitlement of the selling agent to receive an agreed commission on the sale of a property. Under an exclusive agency, a selling agent is entitled on the sale and in accordance with the terms of the agreement with the seller, to receive the agreed commission whether or not the selling agent is the effective cause of sale. So even if the agent appointed under an exclusive agency had nothing to do with the sale in reality, they're still entitled to their commission. So from an agent's perspective, exclusive agencies, I would think, are the way to go. Now, subsection 3 says, but if the sale was subject to a sole agency, the selling agent would not be entitled to a commission if the seller was the effective cause of sale. So can you see the difference between those three types of appointments now? All right. Think about what are the advantages and disadvantages from the perspective of the seller and or the agent. In the section, you'll see an example, and listen to these facts and see if you can provide the correct answer. Here are the facts. The seller is the owner of a place of residence that the seller appoints the agent to sell, the real estate agent to sell. The buyer buys the place of residence and assume that in the following circumstances, these people are the effective cause of the sale. In case number 1, the real estate agent is the effective cause of the sale. The agent will receive the commission. Case 2, another property agent is the effective cause of the sale. Case 3, the seller's mother happens to be the effective cause of the sale. And in case 4, the seller, him or herself, is the effective cause of the sale. So in the section it says very clearly, if the selling agent is under an exclusive agency, then the agent is entitled to the commission on all 4 scenarios. If appointed under a sole agency, entitled to commission only in relation to cases 1, 2, or 3. So do you follow that? I hope I haven't gone too quickly, but have a look at the section 23 if you've struggled to follow that. Now, in terms of appointing a property agent or residential letting agent, refer to sections 102 to 114 inclusive, which we call Part 4. And it sets out the requirement for appointing a property agent for sole or exclusive agency. Section 103 provides for those particulars. And that section only applies for sole or exclusive agencies. And in essence, it imposes an obligation on a real estate agent to give a client notice in approved form, information about sole and exclusive agency appointments. And in addition to that, there is a positive obligation on the agent to discuss with the client whether it will be a sole or exclusive agency, what are the proposed terms of the appointment, the client's entitlement to negotiate the terms up to a maximum of 90 days, and the consequences for the client if the property is sold by someone other than the agent during that period of time. So the agent has a positive obligation to explain these things that we've talked about tonight to the seller, and that's in section 103. Section 104 provides for the general content of the appointment, and what you need to consider there is that there's a distinction between a single appointment or a continuing appointment, and a continuing appointment is one where you need to see section 102 subsection 5b, and a single appointment is 102 5a. I'll leave you to read that for yourself. But in the statement about the appointment, the agent must ensure that they describe the services to be performed, the fees, the charges, the expenses including advertising and marketing, which are normally on top of the commission, and the sources or value or amounts of rebates, discounts, commissions, or other benefits the agent may receive for any expenses that the agent may incur in connection with the performance of the service. All right, so that's section 104. The next is just have a look at the issues regarding disclosure of relationship and benefits. Agents are under an obligation to disclose matters referred to in the Act, and in that regard referred to Part 6, which is sections 152 to 158 inclusive, and there's a Form 8 disclosure where the buyer is to a buyer where the agent expects to receive a benefit from a referral. So section 157 talks about disclosure to a prospective buyer. So this is not the seller, this is to the buyer, and the agent must disclose to a prospective buyer any relationship and the nature of the relationship that the agent has with a referred entity with whom the agent refers a buyer for professional services. So if the agent refers the buyer to some form of professional and there's some financial tie-up, there's some benefit that flows to the agent as a result of that, then it's incumbent upon the agent to disclose that to the buyer. Have a look at Part 7 of the Property Occupations Act for issues to do with residential property sales. So this is sections 159 to 168. 159 deals with definitions, and this is where we see the information about cooling off periods and termination penalties. Now, we talked about that last week. Does everyone understand roughly what we mean by this cooling off period concept? How it might work? Yes? All right. It doesn't apply to all contracts, only some contracts. So have a look at section 160, which provides for what we mean by a relevant contract. So in essence, it's a residential property contract, but as we mentioned last week, not a contract by auction or a contract that entered into on the second clear day after the property was passed in by auction, or a later contract which may have been formed as a result of, say, an option that had been granted, or a contract if the buyer is publicly listed company, or the buyer is a state or statutory body, or whether the buyer is buying more than three or more lots in the one contract, or otherwise. So otherwise, a residential real estate contract is what we call a relevant contract, and in those circumstances, the buyer is entitled to exercise rights to terminate the contract within the cooling off period. How many days is the cooling off period? 5, yes. Kayla won that one because she just showed me the 5 rather than type it, so good move. Rachel came in a quick second. What type of days?
Business days.
Business days, excellent. And when does it start? When does the cooling off period start? Is it the date of contract? Kayla says the date of contract. Is it? Is it possible that it's not the day of contract? Is it possible that the cooling off period commences after the date upon which the contract becomes binding on all the parties? Remember last week or the week before we talked about communication as being one of the elements for a contract? Now, it says, I always thought it was for the other contracts, not sure for conveyancing. Any thoughts? Have a look at section 166, subsection A1, which talks about the time, the date that the cooling off period starts. There's a phrase there, and it says, it starts on the day the buyer receives a copy of the relevant contract signed by both parties from the seller. Is that phrase equivalent to the concept of communication of acceptance of an offer? or is it potentially different? I think it's different. In other words, if the buyer signs a contract on Saturday, the seller signs the contract on Saturday afternoon, and on Saturday evening, the agent phones the buyer to say, congratulations, your contract is signed and we'll get it to you on Monday. I think you could argue that the contract is formed on Saturday, and that would be the date of the contract, I should think. But the cooling off period doesn't start until the Monday, when the buyer receives a copy of the relevant contract. If you have a different view, please let me know. If you think there's a different argument, then that's fine. All right. And that might be a good discussion for you, crew. And these are the sorts of things that you can expect in the examination, where there might be a factual situation, and I'll be asking you things like, when does the cooling off period start, etc. So that's why I think it's really important you have a clear knowledge of this legislation. And the problem is that whilst these things might seem simple enough when you look at them, there's actually a bit of nuance in this, and we're talking about something really important. So what we're talking about is potentially a young couple who come to you and say, we've just heard something wrong with the property, or we have finance, we signed a cash contract, but the finance has fallen through because, Dad's mad with us and now he says he's not going to give us the money after all. Can you get us out of this deal? If you look at the contract and it's dated Saturday and you say, I'm sorry, you've just missed the cooling off period, whereas in fact, the cooling off period didn't start till Monday, then what does that mean? If you got it wrong and you miscalculated the days of the cooling off period, what it means is that these poor clients are now in an awful panic, and your law firm needs to contact somebody to say, I think we've made a dreadful error. Who would you contact as a law firm to say, I think we've made a dreadful error on a conveyancing matter?
The insurer.
Yeah, the insurer. Yep. And the insurer is Bronwyn? Can't remember their name. Now, I think you should know this, because didn't I provide some information from Lexon Insurance in the Moodle material? I think it's there. The information that comes from the RAIQ is very good. The Queensland Law Society, very authoritative. Lexon, have a close look at that. So I need you to look at the information, the basic contracts, have a look at the Lexon QLS material and the Property Occupations Act, and really become very knowledgeable about some of the detail. I actually think this is all really interesting and important work. Okay, so we're talking about the cooling off period, section 166. I want you to also consider this. The proposed relevant contract must include certain matters when it's given to a buyer for signing. So now we're going back to the stage where the agent has a contract ready to give to the buyer. The Act sections 160 and 165 say that an agent must give a buyer a warning statement, and failure to do so exposes the agent to a penalty. This is only in relation to residential property. Where do you think we'd find the definition of residential property? Can anyone tell me where to find the meaning of residential property? Yes, in the Act. Whereabouts in the Act? Rachel said, it's a good statement, definitions. Normally it is, but in this instance it's not, which is why I asked. So usually there'll be a definitions schedule, typically. Section 21, very good, Kayla, found it. So meaning residential property is real property that is used or intended to be used for residential purposes, but does not include real property that is used primarily for industry, commerce, or primary production. So again, in a little nuance, you can sort of expect maybe these sorts of things in the exam. You know, someone buys a property as their home, but really it's a commercial property and they have a little unit up, you know, on the first floor. They happen to live there, but it's really a commercial property. Does the cooling off period provisions apply to that person? Probably not, even though it's, from their perspective, residential property. It is intended to be primarily used as a commercial premises. So you need to understand the sections, the definitions, and also importantly, know where to look. Okay, so have a look at section 165, which talks about the information that must be given to a buyer in the statement prior to signing. And part of that information is information about the cooling off period where it's relevant. Subsection 2 of that section says that the seller must ensure the proposed relevant contract includes the following conspicuously written words or words to this effect. The contract may be subject to a 5 business day statutory cooling off period. A termination penalty of 0.25% of the purchase price applies if the buyer terminates the contract during the statutory cooling off period. It is recommended the buyer obtain independent property valuation and legal advice about the contract and his or her cooling off rights before signing. So if you're acting for a seller who comes to you and says, we want you to look over this contract for the sale of our home. We've decided not to go through an agent. We're going private sale. It's actually our neighbours that are buying the property. You may have a question in the examination, for example. Is that something that, is there some clause that must be inserted that deals with termination rights and termination penalties under the cooling off periods? I think it does. I think that that provision applies to a seller as much as it does to an agent. In that regard, have a look at subsection 5, where it says that subsections 2 or 3 are contravened if the seller commits the offence, if selling personally or giving that to the buyer, or the agent commits the offence. Waiving or shortening cooling off periods, that's possible. Have a look at section 167. The buyer may waive the cooling off period altogether by giving written notice to the seller of the waiver. A buyer under a relevant contract may shorten the cooling off period for the relevant contract by giving notice of shortening period. Question about the exam, is it take-home paper? I think it is. I think it is. Was it on a Thursday evening? Around about the 4th or 5th of October, something along those lines. So have that date clearly in mind, so thank you. Section 168 deals with termination relevant contracts during the cooling off period. Now remember, of course, that if you're acting for a buyer and you have an opportunity to exercise rights to terminate a contract during a cooling off period, that may not always be the best way to go, because there may be some other basis upon which you can lawfully terminate the contract. Just keep that in mind, but do it ethically. For example, there's always a temptation, I think, for people to say, "I'll just crash the contract, just say that finance was not approved." Do you understand the difference? See, so if you said, "No, it didn't get finance," the advantage to the buyer on its face is you get the full deposit back and there's no penalty. Whereas if you exercise cooling off, then there is a penalty payment. So the buyer might be tempted to say, "Well, just tell them I didn't get finance." Are you allowed to do that as a buyer? What if you actually haven't even applied and you say, "No, just terminate," because you say, "I haven't got finance"? Are there any ramifications to the lawyers involved in that if you act on that instruction? What are your thoughts?
They have to provide at least a letter of, like the seller can ask for a letter of termination, like finance decline. And I think under the current contract, you actually may have to provide two unless you specify one lender. If you say any financial institution, you have to provide two in the finance clause. So.
Yeah. So have a look at the standard clause in the contract, as Bronwyn has suggested. Rachel says it's a lie, and I think that's entirely relevant as well. So just be careful. I remember on one occasion years ago, I took on a buyer, acting for a seller, I took on a buyer, effectively saying something like, your application was not a genuine rejection of a loan. And what I did to support that was we did some investigation work, and we found that the buyer had actually bought another property. So that gave us good grounds to say you were able to get the finance, but you just chose to use it towards the acquisition of a different property and the approval or the rejection, because there was a letter, we were saying the rejection letter was not genuine. Interesting things that you might think about. Which brings me to the next topic, little segue, and you're doing well. You're all hanging in there well. A common theme throughout the unit will be, that's all very well, but what can we do about it? In that regard, have a look at Part 10 of the Property Occupations Act, sections 191 to 205, and it deals with the power of the district court to grant injunctions, to deal with undertakings, and to preserve assets and impose civil penalties. Section 191 outlines the grounds upon which a district court may grant an injunction. Now, do we know what we mean by do you know what I mean by an injunction? So what's an injunction? To enforce the contract or to stop. So Rachel says it's to positive thing. Leonie says it's to stop something. Bronwyn says to stop something. Kayla says it's an order of the court. The answer is it's a combination of all of those things. It is an order of the court, and injunctions are of two basic types. We have a mandatory or positive injunction, which is effectively to enforce something, force someone to do something. We have a prohibitory injunction or a negative injunction to stop someone from doing something. So it can work both ways. So the district court has power to grant the injunction. And the court can grant the injunction or provide the other relief if it is satisfied that there has been a contravention of the Act or prescribed conduct provision or an attempt to do so, or someone has been aiding, abetting, counselling or procuring someone else to do so, or inducing or attempting to induce someone to do so, being in any way directly or indirectly knowingly concerned in or a party to the contravention, or conspiring with other persons to contravene the Act. There's a whole lot of things. That's very broad language. And if we talk about the court having power to grant an injunction, if it's satisfied that there has been, let's say, someone aiding or abetting or counselling someone to attempt to contravene the Act, then that person who has been involved in the process of aiding or abetting an attempt to contravene the Act may find themselves listed as one of the respondents on an application seeking an injunction. I'm sure that as legal advisors, you don't want to be that person. You don't want to be in a position where you get an application with your name on it saying you are a party who have aided or abetted someone who is attempting to contravene the Act. Do you see where I'm going with this? So the powers are very broad, and the basis upon which the court can make the injunction or other order is also broad. Now, I did mention that it has power to do so if it is satisfied there's a contravention of the Act or a contravention of a prescribed conduct provision. What's a conduct provision? Where do we find these conduct provisions? Okay, have a look at. Yeah, sorry. What was that, Bronwyn?
Solicitors' conduct rules, or
yeah, I think so. Have a look at section 235, and it provides that regulations may prescribe conduct standards, but they're primarily standards for auctioneers, real estate agents, and letting agents, and that provides some information about prescribed conduct provisions. But as far as lawyers are concerned, yeah, I think the Australian Solicitors' Conduct Rules. Now, section 192 talks about who may apply for the injunction, and it's very broad. It might be the chief executive, or even more broadly, a person aggrieved by the respondent's conduct. That's really broad. Section 194 talks about the court's power for the injunction, and the court may grant the injunction restraining a respondent from engaging in conduct, whether or not it appears to the court that the respondent intends to engage again or continue to engage again in conduct, whether the respondent had previously engaged in that conduct, and the power of the court to grant the injunction may be exercised in broad circumstances. Note also section 202 of the Act, which provides for powers of the court to preserve assets. Has anyone done civil procedure? If you've done civil procedure, you might be familiar with that term, preservation of assets, which the counterpart in the UCPR is Rule 260, which deals with freezing orders, which is a Morava injunction or Morava orders. So that's a counterpart for that. All right, we're almost closing up. So thank you for your patience. I just want to deal with a little bit more, and that is to do with the concept of misleading or unconscionable conduct or misrepresentation by a marketer in relation to residential real estate. Now, a marketeer means a person directly involved or indirectly involved, alone or with others, in the sale, promotion, or provision of services regarding the sale of property. And the thing that's interesting there is that the definition goes so far as to include a reference to a person who provides advisory, management, or legal, or accounting, or administrative or other services in connection with the sale. So that's another way in which a lawyer can be even personally dragged into litigation as a party on the basis that they are a marketeer because they are a person who has been providing legal services in relation to a contravention issue. Have a look at section 207, dealing with misleading conduct. Have a look at section 208, dealing with unconscionable conduct, and section 209, which deals with false representations and other misleading conduct. And that might do us for tonight. Are there any questions, comments? All good? Yes, Bronwyn?
I'm just wondering, with that section 207 and misleading and deceptive conduct sort of marketeers, is that why the Property Occupations Act was brought in and the cooling off period? Because I remember back in the 90s, or saying how old I am now, but there was all marketeering companies who were bringing clients up from Victoria to the Gold Coast and marketing and selling, and you know, people didn't have a cooling off period, I don't think.
Yes. Back then there was no cooling off period. So I think you're right. I think that was a great impetus for this type of material.
Why that came in.
Yeah. Yep. And the whole cooling off period as well. So I guess one of the lessons for tonight is that as lawyers involved in the process of conveyancing, you need to understand that this is not easy. It requires a very keen eye. You need to read very carefully and broadly. You need to be aware of how you can get roped in personally to issues of concern by the broad definitions, and you can have a better understanding of the remedies that are available, particularly through the injunctive relief available in the district court. Okay, so if in the exam question there's an issue and I say, what can you do about it? Where would you go for the injunction? I would hope that if it's a question that relates to the Property Occupations Act, you'll say district court. All right. Any other questions, comments? All good? Thank you for your patience, and we'll see you next week. All the best. Bye.